So my name is Loukas Mistelis. I'm the Clive Smith Professor of Transnational Commercial and Arbitration. One of my key roles within the school is to develop the current LLM program. And we think we have developed the broadest and so the most sort of sophisticated program in dispute resolution. As part of that, and one of the modules which are exclusive to dispute resolution students and sort of mandatory flagship module is the module called International Arbitration Law and Practice number 2 with applicable law and procedures. This module can be taken from students who have some experience in arbitration or have no experience whatsoever, because what we're going to do is we're going to take a very advanced look at how the arbitration works when the parties are in the arbitration. We don't look at jurisdiction, we don't look at the arbitration agreement, but we look at, once the arbitration started, all the key components of the process. For example, we're looking at how parties can present evidence, how they can present their case, and how they can support the cases with formal, factual, or technical legal experts. We are also looking at how submissions are being produced. We look at different styles of doing that, sort of common law versus civil law, hybrids that have developed over the years. And we are also looking at specific procedural mechanisms, for example, how we can join third parties who are not signatories to the arbitration, how we can consolidate multiple arbitrations. We also look at other processes that ensure the efficiency of the process. And we also look at things like emergency arbitration or interim relief, how you ensure that when you, a few months or years perhaps down the line, when you have an award, you have something to enforce against. So it is a module that therefore looks at a number of very real-life practical issues. We also look at how the tribunal determines the law that governs the arbitration, the law that governs the substance of the dispute, and we looked at the various mechanisms that this can happen. It's a comparative law module. Therefore, we look at all the major jurisdictions, including, of course, the UK, France, Switzerland, the US. But also we look at the Unsettled Model Law, which is a law that is adopted by nearly 90 jurisdictions. And depending on the particular student population, we also look at other jurisdictions which might be relevant. It could be Chinese law, it could be Brazilian law, it could be Russian law or Egyptian law. That makes the process much more real life. And we also look at how hard law that is generated through a national legislator, interacts with soft law, trade usages and customs that the arbitration community has developed. It's quite a bit of a practical module, but we try to give also the theoretical context and explain why we do things in a particular way, but also why the parties can agree to deviate from certain proceedings. We have also have an opportunity in the module to do a few more practical matters, like sort of design a case management conference, look at how procedural orders are being prepared and drafted, and therefore we prepare students to perhaps even be able to practice as a result of that module. But ultimately, it is an academic subject. The assessment is through a take-home exam, an online exam that takes roughly about 4.5 hours to produce. And again, we don't care about sort of short-term memory. We test critical understanding of the key concepts.